Good evening. Welcome to tonight's Legal Corner. While students in HKU struggling to finish their company law during the Chinese New Year with a demanding professor, we have upcoming stories on the dramatic increase in the number of cases reported regarding the minority shareholders' protections over the last few years. However, the most recent case involving the land development company Taiwa Land Investment was dismissed this afternoon for failing to establish the facts on unfair prejudice. We have our legal correspondent Victor Wang with us, and let's hear the details from him. Victor, could you tell us what has happened with Taiwan Land Investment case that has brought so much public attention these days?
Thanks, Hong. The petition was brought to the court by one of the directors of the company, and also he is the minority shareholder. The major complaints he made were about unfair prejudicial the major shareholder placed upon him. Let's now take a look to the relationship charts. Mr. Leung, the petitioner, YC's son, and YC's brother form four directors of the company. YC's son, and YC's brother own the major shares of the company. That left Mr. Leung as a minority shareholder. Mr. Leung had two major complaints. First, when the company was originally established, it was agreed that it would be developed with borrowed money and out of accumulated income, and that new shares would not be issued. Second, the parties subsequently disagreed over the development of a site which had been purchased by the company on its incorporation, the development of which would have required a considerable capital contribution by the parties. It was alleged that this was outside the parties' original agreement, on which the petitioner placed great reliance and unfairly prejudicial to the petitioner. In order to establish unfair prejudicial, the judge found the following facts. First, it is a domestic small company with 4 directors. Second, participation in the company was based on personal relationships and mutual trusts and confidence. Third, the petitioner was locked in to the company as it would be difficult for him to dispose of his shares in a small private company. This was before the amendment to Section 49, which may make shares disposal easier if the company itself is in a position to buy back its own shares, and the parties are willing to use this as a way of resolving a shareholders' dispute. With the above circumstances, any departure from any understanding between parties when the company was established could be unfairly prejudicial.
Thanks, Victor. We are very much honored indeed to have our legal expert Eric with us to look into the case. Thank you, Eric. Okay, first let me begin by asking a question. What seems to be the buzzword in the legal industry? Unfair prejudice. It sounds very difficult to understand by the context. And could you enlighten us and the viewers who may not have the legal background about this term, unfair prejudice?
Yeah, sure. According to a South African case, Don Nosan Investments versus Angelo Transfer College Trees, the judge gave the following definition. The applicants must establish that the majority shareholders are using their greater voting power in a manner which does not enable the minority to enjoy a fair participation in the affairs of a company. The emphasis is on the unfairness of the conduct complained of. It must be a conduct which departs from the accepted standards of fair pay or which amounts to an unfair discrimination against.
So then why do you think Mr. Leung lost his case?
Yeah, actually the judge gave the following judgments. First, the judge did not think that there was any understanding between the parties, and if so, Mr. Leung should have brought the case up earlier. Second, Mr. Leung accepted in cross-examination. All suggestions put to him indicate that a right issue could be regarded as a commercially sensible way of raising money. In the absence of improper motives, the judge was not able to accept that the complaint can amount to unfairly prejudicial conduct within the meaning of Section 168 Cap A. Thirdly, in fact, Mr. Leung had accepted that he had been prepared to consider any opportunities as it arises, provided that there was money in it, and did not point against the existence of any understanding. Moreover, he had not inquired about the feasibility of others participating in the hotel operation or any indication that there was no understanding. Therefore, Mr. Leung was merely considering the options were open, and hence unfair prejudice did not exist. And lastly, the judge mentioned that the feeling of annoyance, frustration, and aspiration at being upvoted are clearly not enough. I do not wish to be unkind to Mr. Leung. However, it does seem to me that all petitions have revealed that he was in disagreement with the majority, which is a situation that inevitably faces minority shareholders from time to time.
Oh, I see. Thank you very much for Eric's thorough explanation. That was actually very interesting. Whoever said the law was boring, he was clearly wrong. Here comes to the end of tonight's Legal Corner. We will come back with the more interesting stories and news on the current legal issues. Thank you for watching.